Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
You, on the second occasion, to come and give evidence to our committee this morning. We've got a lot of ground to cover, and it will not be necessary for all of you to answer every question, because we've also got a second panel representing British citizens living in other EU countries who we'll be hearing from today. Can I welcome then specifically Nicholas Hatton, co-chair of the 3 Million, Anne-Laure Donskoy, co-chair of the 3 Million, Barbara Drodzowicz, Chief Executive Officer of the East European Resource Centre, Dr Mary Tilkey, Member and former Chair of Irish in Britain, and Catherine Hennessy, Trustee of Irish in Britain. You are all most welcome. Can I kick off by asking you, Dr Tilkey and Miss Hennessy, Irish nationals in the UK obviously have a very specific and special status, and the common travel area predates our membership of the European community. It'd be really helpful if you could set out whether there are any areas of uncertainty affecting Irish people living in Britain that you're worried about or have been brought to your attention, because there really hasn't been much focus on this thus far, because the government has said, well, the common travel area will continue as the case before, but obviously the law has moved on a bit since then. I don't know which of you would like to go first.
I can start.
Yes, please. Thank you.
Okay. I'll begin by saying Irish in Britain is a national membership organisation established in 1973 and representing about 120 Irish organisations throughout Britain. The questions I'm going to be answering today address the views and concerns of our membership as Irish citizens. Mm-hmm. However, as EU citizens, we also have solidarity with other EU citizens and those representing them here today. Irish in Britain welcomes the joint UK and Irish commitment to the preservation of the common travel area as set out in the joint report of the EU and UK negotiators in December 2017. It is our experience, though, that recent events, such as the Windrush controversy and the so-called hostile environment, have dented the community's confidence in reliance on the common travel area to some degree. In particular, we've seen that older members of the population are particularly anxious that they may have to demonstrate, for instance, their rights to benefits, healthcare and housing. And many fear they will not have the documentation required, given that their early employment may have been of a casual nature and have taken place several years ago because they're now retired.
Right. So have you as an organisation had any conversations with the Home Office or any other parts of government about how this is going to work?
To date, we haven't. To date, as Irish organisations in Britain, we've liaised primarily with the Irish Department of Foreign Affairs and the Irish Embassy in London, and have sought information from them. We understand that a publicity campaign is planned to communicate with EU citizens in order to advise them on regularising their status. And notwithstanding the plans of the Irish government to provide information for its citizens on the common travel area, we would recommend that Irish nationals are offered additional information on their rights within the common travel area by the UK authorities.
Right, but presumably you would be of the view that if advice to EU citizens in the UK about how they should regularise position was in any way interpreted as applying to Irish citizens living in Britain, that really would cause concern, because it would throw into question, would it not, the argument that has been put by the government, namely that those people's rights are unaffected.
Yes.
So you need separate information.
Separate information.
Yeah. Yes, please, Dr Tilkey.
I think we need separate information to the Irish community.
Right.
And I think we also need information to various government departments, and since so many government departments have outsourced their services, it's important that information gets to those as well. We have some anecdotal evidence of people having problems already with the habitual residency test when they go for benefits and things like that. So I think it's really important that the message is clear that Irish citizens have got different rights and entitlements than some other EU citizens have. I think it's also important to say that our community in Britain has got a very old age profile in comparison with many of the other minority communities or indeed EU communities. So many of these older people will not have access to computers, they won't have access to the internet. So it's important that information gets out there in accessible formats for an older community. So I think it's really people are becoming more anxious, particularly since the Windrush events. I think people were a bit anxious before then, but I think it's raised their anxiety level considerably.
But is your understanding at the moment that there's nothing that Irish citizens will have to do when we leave the European Union, unlike the 3 million EU citizens who the government says will need to apply for settled status? That doesn't apply. So is it your understanding that there is anything, when you're advising your members and they say, do I need to do anything? The answer currently is...
I think the advice from us would be that you don't need to do anything at the moment, but that would not necessarily be the understanding within the community, who will be talking to people from other European communities and other parts of the world as well. So I think what we think and what they think might be very different.
Two different things. Have you seen the report by Simon Cox, QC, which stated that the status of Irish nationals in the UK rests predominantly on EU law rather than the Common Travel Area or the Ireland Act 1949? If you have seen that, did that give you any cause for concern?
Well, I mean, Irish and Britain recognises that many of the arrangements of the Common Travel Area are evolutionary and implicit, and therefore not subject to specific legislation or indeed of an international agreement. So we do await further details on the justice and security regulations for Irish citizens, which we think will sit outside the Common Travel Area arrangements.
And what do you think that might cover, and how might that affect Irish citizens in the UK?
Well, our concern would be the potential, say, for deportation, issues such as that in matters where there are criminal convictions and so forth.
Okay. Have you asked for a meeting with the Home Office as an organisation?
No. We have not to date done so.
Right. Are you planning to do so, what you said this morning?
We may well do so, yes.
Okay. That's very helpful. Thank you very much indeed. Emma...
Chair, could I just make one point about the diversity in our community? And I do want to illustrate the difficulties experienced by Irish travellers. It's estimated, and it's only an estimate, that there might be about 100,000 Irish travellers resident in Britain at the moment, and they will have additional difficulty, not just because of their traveller status, but with literacy, with hate crime, and all the other difficulties that they have, poverty and poor health.
Okay, thank you very much indeed. Emma Reynolds.
Thank you. I'd like to address my questions to the co-chairs of the 3 million. You've published a range of technical and substantive concerns about the withdrawal agreement. I wondered whether you could outline whether you think there will be further opportunities for those concerns to be taken on board and for the agreement to be amended.
Thank you. First of all, I'd like to reiterate the fact that the issue of EU citizens' rights has not been resolved. I know it's been said in many different places. It's in green in the withdrawal agreement at the moment, but I can certainly assure you that the issue has not been resolved. So there are many difficulties with the withdrawal agreement, the draft withdrawal agreement as it currently stands. In many ways, it's weaker than the joint report of December. There are issues which have not been translated very well into it. We do hope, certainly, there will be opportunities to bring in amendments, in particular to strengthen the rights of EU citizens and offer proper, robust guarantees. A lot of We do welcome the fact that the UK government has gone beyond certain aspects of the joint report and the withdrawal agreement, but at the moment these are, shall we say, nice political statements which still need to be translated into robust law.
Could you outline, you said that the issue is not resolved. What are the main outstanding issues for you?
There are many. A couple of the documents which were published by this House, for instance, mentioned the comprehensive sickness insurance.
Sure.
That is still a pending question. It's a big question, not just for people who will be subjected for the settled status migration scheme, but also for people who are currently still applying for permanent residence with a view often to apply for British citizenship. Those people in particular, if they weren't able to provide evidence of having had comprehensive sickness insurance, get their application for permanent residence rejected. We ask that the UK government starts getting rid of comprehensive sickness insurance now. That would facilitate the process, it would encourage people to apply, and further on along the line they would apply for British citizenship. But also, as I said, at the moment, the comprehensive sickness insurance requirement it's just only mentioned that it will no longer be applied along with the test for genuine and effective work. But these are just statements. We need to see more than this. And whenever we have asked the Home Office about this, and some of us belong to the user groups, I belong in particular to the vulnerable EU citizens user group, when we've asked, okay, so what do you mean, you know, it will be, though some people will still be affected. So who are these people who will still be affected? How? At what point? Who are those cohorts? What will happen to them if they cannot provide evidence of a comprehensive sickness insurance? We have no answers to this. The latest we heard is there will be an announcement soon. We're still waiting. So that really doesn't help with the feeling of uncertainty.
And I add to this is so we've been told by we've been told in the Home Office users group, which are the sort of a consultation of EU citizen organisations and other organisations. So we've been told that there will be a positive approach towards application, so that people who are filling their status applications, if they're missing one document or two, they'll be looked favourably. But what we're asking is, why can't this approach start now? Why wait? Because there's a lot of anxiety among EU citizens because of the refusals of permanent residence applications, and that positive approach could actually be implemented as of today if they wanted to, because that would reassure people that the Home Office generally wants us to stay. At the moment, the perception is that there's a lot of hoops and it's complicated, and in some way the bureaucratic machine is used to prevent people from getting documented. And that, you know, a word saying this will stop is not enough. It should really stop now.
What is the impact of the lack of clarity and uncertainty that you outlined on the people that you represent? How does it make them behave, act? Are some of them returning to their own countries as a result? What is the impact?
The impact is huge. There's a lot of impact on at the individual level. A lot of people are feeling not just concerned, they're extremely worried. They're extremely worried for themselves, they're extremely worried for their families, the future of their families, what will happen to them. For instance, in particular, if there is no deal. That is a really very big worry, because if there is no deal, all EU citizens will automatically fall back onto an immigration system which was never designed for them in the first place. You know, they've come here under free movement laws, and they're being asked to be slotted into a constitutive system which will never work for them. And if, you know, we're told that the withdrawal agreement will have, in a way, a sort of copy and paste of EU directive into it, that's not going to work, because the EU directive comes from a declaratory system. So you're trying to transform a declarative system into a constitutive system, and that cannot work. It creates a lot of problems.
If I may add to that, I represent East European Research Centre, represent mainly Eastern Europeans, but essentially those EU nationals who are most disadvantaged, isolated, marginalised, and there is quite a large proportion of those people working in low-income jobs or facing housing issue, worker exploitation, and so on and so forth. Within that group, what really worries us is that we have noticed quite the opposite response among some sections of people who feel they are completely disengaged from the Brexit process and from the future immigration scheme. What really worries us is that some sections of people just seem to choose, if you can choose that, to be in some form of immigration denial. Therefore, uncertainty has been with us for so long, it has been so deeply normalized that people just refuse to engage full stop. So what worries us that people will not register to the scheme, not for any malevolent reason. They just don't understand why they should be doing that. The logic is, I've been here 8 years, or 10 years, or 12, or 15. I've been working. The government can go and check Revenue and Customs basically records. I've been here legally. Everything is fine. I'm not going to do anything about that. The other problem that people are slightly worried about is the cost of the scheme. We understand that the cost is, comparing with other immigration documentation, is moderate because it's not more than application for British passport as far as I can tell. However, if we are looking at families of more than 4, let's say, that consist of low-income earners plus children, this is quite high expenditure, and we were slightly worried that there doesn't seem to be any way of waive or reduce fees looking at the income level or circumstances. And there are also 2 other groups of people, broadly speaking, that will be affected by the uncertainty specifically about what's going on now. Some of them will be those who will struggle accessing the scheme, the process, full stop. So, for example, children who are in care. We don't know who is going to apply for them, who is going to pay fees. If they are in care of local authorities, that will probably become duty of local authorities, but this is not something that we are entirely clear about. Older people in residential care facilities who might be isolated with no other family members. Again, if there are frail health, if there are issues around impact of dementia and so on and so forth, expecting people to be able to apply, especially online, for themselves is going to be really, it's a quite high risk, this group. Again, it is not clear for us what sort of support will be given to these particular vulnerable groups. We have been working with Home Office within the working groups around safeguarding of these risk groups. But then again, we still don't know where we are going with this, therefore it's hard to make any decisions to anyone, even including decisions of upskilling community as a whole just to make it happen for itself. That brings the problem of immigration advice, because it will be needed, and it has to be qualified, and it has to be supported for those people who will not be able to pay for it. If you would look into cost of immigration advice currently, even applications, simple applications for permanent residence documentation right now, through immigration solicitors can cost from £800 upwards. Single application that is not complicated, it does not involve derivative rights, and so on and so forth. So access to information and advice is going to hamper people's engagement with the scheme. And because we still don't quite know how the scheme is going to look like, it's difficult for even community organizations, charities, or educational facilities to start cascading information how people should be prepared.
That's really helpful. One last question. Yeah. So from what you're saying, you're concerned that there'll be many particularly hard to reach people, vulnerable people who are in low-income groups, who perhaps just won't engage at all and won't apply for settled status. Has the Windrush scandal dented further people's confidence in the competence of the Home Office to deal with their cases appropriately?
Certainly. The 3 million is not agitating the Windrush ghost at all, but we have been saying, we produced in the autumn of last year, we produced a document which was going to be an alternative to settled status, in which we clearly set out in detail what would be the danger of falling within an indefinite leave to remain project. And basically what we said would happen has happened, very unfortunately, to the Windrush citizens. So our fears, our concerns are very grounded. So there is really urgency to address all of those issues. So how do you make sure that 3.6 million EU citizens are covered, have the right documents, and within what is effectively a very short time? And as my colleague mentioned, we are both attending the same safeguarding user group that the Home Office has set up. This is only the second meeting that's just happened, and I've had to make noises to say, look, this is not going to happen. If we're just having a couple of hours meeting, which are not 2 hours, in 3 months, and there's going to be the summer, and this scheme is meant to be set up and running by the autumn. There is not a chance in hell this is going to happen, because this group is still trying to find out, still trying to assess exactly who are the people who are at risk, who are vulnerable of becoming undocumented, therefore illegal, therefore highly likely to be deported at some stage. And if they are illegal, all of a sudden they will lose access to services, they will lose access to work, lose access to bank accounts. It's the worst possible situation. So there are many, many people who will be have enormous difficulties engaging with the process, and vice versa.
Okay, thank you very much. Stephen Timmins.
Thank you. You've emphasised in the points you've made so far some of the points that are not covered in the draft withdrawal agreement, things still to be resolved. But it does obviously contain some important reassurances for EU citizens in the UK. I'm wondering, are you satisfied that if agreement is satisfactorily concluded around about October or whenever it is, that the reassurances that are in the draft agreement will be delivered? Is there sufficient reassurance? I think you talked earlier about the need to put things into robust law, I think was the phrase that you used. What do you mean by that? What's necessary to translate these assurances that are in the agreement into sufficient, to make you sufficiently confident that they will be delivered?
So we know that the withdrawal agreement will be ratified and be translated into primary legislation as well. So that is as robust as it gets. The issue we've got with the withdrawal agreement is that there are gaps. So what's not covered, or what level of details there is in the withdrawal agreement. So if I take the example of the right to return, in the withdrawal agreement, there is a 5-year limit for that right to return. So if I'm an EU, like me, if I get a job abroad and let's assume I've got settled status, after 5 years, if I haven't come back because the job is still there, I will not be able to keep settled status, and then my immigration status will revert as a third country national. So there are gaps like this in the withdrawal agreement. So the mechanism for implementing it, I think, is fine. There is direct effect. We know that we'll be able to invoke the withdrawal agreement in courts.
So your concern is about the gaps in the agreement, not so much about the translation of what is there into reliable law. You're happy with the way that will happen?
Not quite, because the withdrawal agreement is not very precise, and there are different ways of interpreting this agreement. Yeah. So when it comes to the application for settled status, the withdrawal agreement provides two options, declarative or constitutive. And what we'd like to see is a protocol that would be an appendix to the withdrawal agreement, which would set in much more detail how the withdrawal agreement would be implemented for EU citizens in the UK, so we get more certainty. The withdrawal agreement itself doesn't give us enough certainty.
Okay. Can I ask, have any of you been consulted on plans for the independent monitoring authority for EU citizens in the UK?
No, we don't know enough about what's very important. Two words important: independent and authority. And I think in the past what we've seen is that these authorities are neither being independent nor being authorities. And I think it's going to be really, really key, because 3 million people will have to apply for a scheme. There's going to be issues, problems, errors, and they need to have a way to appeal. They need to have a way to effectively reverse a decision if it's erroneous. And we haven't been offered any details on this.
Have you seen any plans for the authority? It hasn't come up at your meetings with the Home Office?
No,
No.
Not yet.
There's nothing beyond what's in the current draft. And it's a little bit of a problem. It feels like the EU says, well, actually, it looks like this is a monitoring issue for the UK, therefore we leave it to the UK to sort out. Except we feel it should very much be a UK-EU independent authority with real powers, so that our rights are properly monitored. But also, if there are any issues, we can go to this authority in confidence and trust, that they will do the right thing by us.
Have you got any sort of models in mind for the kind of thing that would be reassuring? That can you think of any other independent authorities that would give a model that could do this job? Or
we are currently working on a document which is looking in detail at all of those issues.
Okay. Well, we'll be keen to see that once you have it.
It's a bit of a draft at the moment.
Okay.
Okay. Thank you very much. Joanna Cherry.
Thank you very much, Chair. Good morning. Can I ask I'm very interested in the evidence of the Irish in Britain, and I'd like to thank you for that, because it's the first time we've heard evidence about these specific issues, and many of us have significant numbers of constituents and indeed family members of Irish extraction, so thank you for that. But forgive me if I just focus my questions on the representatives of the 3 million this morning. You sent to the Home Office 150 questions on settled status. I wonder if you could tell us what sort of response you've had to that.
150 questions. That's reality. Just an aside, this is, this shows the scheme is being presented to us and talked up as being something simplified. But as soon as you start scratching the surface, you find actually there's nothing simple about registering 3.6 million people. As soon as you start looking, pretty much a family or a group of people have all come with different issues. And if this scheme, this government wants this scheme, it has to take the responsibility of addressing issues that will automatically come with such a system. And those issues need to be addressed in time.
And, so we met Caroline Noakes last month, the Immigration Minister, and they find these questions actually helpful, because he highlights challenges or issues they might not have realised. She committed to answer these questions in writing. The timeline is not so clear, but we understand that the Home Office will work on an FAQ, frequently asked questions, and my understanding is that the FAQ is based on these questions. I imagine there can be some cherry picking of the questions, and but we'll make sure that we get answers to all the questions, because it goes back to the Home Office and the lack of confidence in the Home Office. To have certainty, we need to know what the scheme looks like, and for this, we need to have it, written black on white. It can't just be declaration in the media or speeches. So I think it's very important that we get answers, and I hope that's helpful for you as well as members of the committee.
And this is also what happens when you move from a declaratory process to a constitutive process. You end up with this. We started with 128 questions. There are now 150 questions and growing.
I mean, did Caroline Noakes give you any indication of the timescale in which you should expect to receive answers to these questions?
Well, the draft FAQ is meant to be circulated in the users group in June, so possibly for publication in the summer, but I don't know more on that.
Okay. Now, you mentioned, Barbara, about the importance of access to information and advice. And I've been discussing this with colleagues in the Scottish Government, and there has been some talk about efforts by the UK Government to involve community groups and public services such as libraries in facilitating settled status applications. But so far as I can make out, these efforts are practically non-existent in Scotland. Only 2 local libraries have been contacted. Do you have any information from the British Government on what efforts they've made to involve community groups and public services such as libraries in assisting with the settled status application?
I think there is currently what we know from Home Office is the digital assistance scheme, which basically is focusing on actually literally helping people go through the digital aspect of the application. Our concern is that, as far as we can tell, it's based in libraries. Therefore, this is not the first place where people who are struggling with, for example, language or literacy barrier would go in the first place. And there is no, so far, solution to the problem of overcoming the barriers. So if the scheme exists to support people who will face problems in accessing the scheme itself is inaccessible. And we don't really, I mean, I don't know what's your view on that, but I don't see any meaningful engagement with the third sector on kind of reaching out and cascading the information, advice and support to most, especially those hard to reach groups, because quite frankly other groups possibly will need information. What we know now is kind of there is some very basic information that is distributed via digital channels such as some social media channels, and that is not sufficient. It is not even sufficient for people who are fully literate and fully fluent in English, not to mention all those other groups.
I mean, the witnesses from the Irish and Britain mentioned that within the Irish and Britain there's an older constituency, and some, but many, but not all older people are perhaps less likely to be using social media and to be sort of IT savvy. I mean, what would you like to see for outreach to older people and other vulnerable groups?
I would say that definitely we need to first, I mean, we have quite a good understanding where are those vulnerable groups for now already. But the problem is that there is no provision for any face-to-face information and advice, and this is the biggest weakness. So, for example, if we are looking at people in residential care, that would apply to all spectrums of vulnerable adults and children as well. I would expect to see at the least some form of champions who will know inside out the immigration status people will have to be taken through. Now, all championship schemes are intrinsically risky because it's relying on the fact that someone will have sufficient ability to pass on for immigration advice effectively, collect the evidence, because that is an element. This is the third issue around any immigration schemes. But this is, we think, absolutely necessary. Another thing is the ability to allow people to apply in person. So to avoid only digital channels, simply because not everyone is confident enough to apply online, especially if that involves smartphone applications, not just plain online laptop, computer in a library scheme.
There's also the issue that a lot of libraries have closed down or are closing down. And those who are still open don't always have computers that work. I use my local library, and I can tell you that's a real problem. There are also the issues that people who will not engage with any forms of any kind. This is not part of what they do. Sometimes they try and get help. I'll give you an example that was given to me by an immigration lawyer of a lady who had to fill in and apply for some kind of an immigration status. So it took many sessions to find the paperwork for her. She doesn't keep anything. Then trying to fill in the form because she was missing details, gets kicked out of the system every 5 minutes. Then, okay, all done and dusted, pay. Let's pay. Let's give the Home Office some money. So you go through a system called WellPay, And the system, quite rightly so, has a security level, so I'm sending you a code to make sure that you're the right person paying this fee. Oh, I don't have a mobile phone. I don't have a smartphone. Oh, let's use the phone, your friend's phone. Your friend's phone's number isn't registered by the bank through which the payment is being made. Payment gets kicked out. And it takes weeks and weeks and weeks for people who have all kinds of levels of difficulties of engaging with any kind of formal process. And these people are not necessarily older people, they are all age. It depends where they come from as well.
On the issue of older people, I think it's really important. I've spoken to many elderly EU citizens. I feel really, really sorry because they feel really anxious about it and they shouldn't. It's really not fair. Most of them have already a status. They got indefinite leave to remain. They got stamped in their passport. And when we've asked the Home Office to say, well, they don't need to apply, they don't need to go through all this. They just need to be reassured that nothing's changed for them. And I think that the Home Office got to do more work on this to make sure that these older residents don't have anything to worry because they're already documented.
You mentioned there a difficulty with paying. The Scottish Government have asked the UK Government to commit to do away with the fee, to have no fee for the settled status application process. Do you think that's a good idea?
It is, and it was in a joint report. A joint report said, excuse me, there should be no fees. But for some reason, it's been reinstated, I think, in the WA and hasn't gone away. And when we talked in the user group, they said, yes, it will no longer be £72. It will be whatever the cost of a British passport will be. And we still think this is totally unfair. And there is, as some of my colleagues have said, there is a huge cost when you have a family. And it's not just the cost of the actual fee, it's everything else around it. Going to a meeting, a face-to-face meeting, if they can be organised, that costs money, it costs time. If you're working, you have to take a day out, blah, blah, blah. It goes on and on. So yes, exactly. There's a lot to be added.
Our understanding is that government does not wish to EU nationals leave Britain after the Brexit. Therefore, we want to make sure that everything is done to facilitate regulating our status. Removing the fee without any complicated waiver process, but if need be, that needs to be done as well, will hugely support people's decision to actually go and do it.
Okay, thank you. Jonathan Janot.
Thank you, Chairman. And just listening to these very helpful contributions from our panellists makes me think that perhaps we should invite an immigration minister on a future occasion, or the committee may wish to consider that. If I could just go back to analysing the government proposals in a little bit more detail so far as known, and I appreciate that since its, I think, 8th of November technical note, the government doesn't seem to have published very much more since that time. I suppose they would say they're in a development stage and they're going to come back, I believe. The online system for settled status should be ready, they're saying, in the second half of 2018. I think that's what Mr. Hatton said earlier, but that you didn't really know any more than that. You didn't have any specific date. It's also indicated that it intends the application process to begin 6 months before the UK leaves the EU, and I'd be interested to hear your views on whether that's likely. The Home Office's ambition is for straightforward applications to be turned around in no more than 2 weeks. It said that it will provide automated acknowledgements of the application upon receipt, and everyone will receive confirmation of the outcome of their application. So, putting those proposals in context, I mean, how confident are you that the Home Office are going to be able to process potentially 3 million plus settled status applications within these timeframes? Mr. Hatton.
So, yes, the date announced is second part of 2018. We've heard about October or end of the year. There's a slight issue here, is that the withdrawal agreement won't be ratified and implemented before the 29th of March 2019. So having a scheme to start beforehand won't be an application of the withdrawal agreement. It will be done through secondary legislation without any statutory right of appeals. So there's a lot of question marks legally on starting the scheme before the withdrawal agreement starts, basically. That's the one thing. Anna, I think you can cover the scheme itself.
Yeah, I mean, so the last we heard was that, from October it's now being moved to sometimes toward the end of the year, no date, indeed. And there is also an issue around that there's a possibility that, and it's actually been described by some government papers I've seen, that there's a pre-withdrawal agreement ratification time is actually been described as a test time, which kind of raises other issues. So will people who would go through this early bird version, test version, will their settled status be as strong legally as those who get it after 29th of March 2019? That is a question that's not been answered yet. And also, there is always a possibility that doing it that way gets less scrutiny than if it started after. There's quite a possibility that, so you imagine that the scheme starts in October, November, December, it doesn't matter. And then there's quite a strong possibility the government will just say, look, it's already started, all we need is just a year from the Parliament and we continue. But that means less scrutiny of this particular model.
Does anyone else want to?
I don't know if you're just in the process itself, but from our point of view, we're told it's going to be digital. There'll be a 2 weeks window for the decision. And basically, in these 2 weeks, the Home Office will check governmental databases like DWP or HMRC to find us, and then try to see whether we've got this 5-year residency period in the UK to enable us to gain settled status. That's obviously bearing in mind that we would have passed the ID check and the criminality check. There's so much to cover in the criminality check. I'm not going to start, but there's allegedly about 20,000 EU citizens a year. We could have a conviction that we could make them fail the settled status application. And the question is, what happens if you fail? Are you going to get a deportation order? What's going to happen? So again, it goes back to the questions, is that this scheme yet is not defined enough for us to have a judgment on it. But we need a lot of scrutiny to make sure it works for 3 million people, because let's be clear, there's no option. All EU citizens need to be documented. It's not an option for them not to be documented. So that should be the objective of the scheme, and I think it is, to be fair.
Yes.
But also in terms of the criminality checks, we certainly strongly oppose that there should be self-declaration. The government already holds a lot of information about people who have convictions of all descriptions. There's no need to ask persons to actually self-declare. Getting people to self-declare, especially people who are a bit more vulnerable, not very much in favour of the law, are much more likely to actually self-declare in the wrong way, make mistakes, and make themselves look like more criminals than they are. So they might declare, a fine, a traffic fine, and you could imagine, okay, conviction out quite quickly. When we see what's going on, especially within the hostile environment, when people who make a very, very minor mistake with their tax return get threatened with deportation, then you can see how dangerous having criminality checks based on self-declaration can be.
But you're not suggesting that there is a hostile environment in this situation?
Well, it's a very good way of trapping people to, make mistakes.
I think with self-declaration on criminal record, the problem is that people really don't understand what Home Office sees as the deportation test. So we get questions from our users, such as I had a shoplifting conviction in 1973 in France. Will that count? And what it does, it makes people again disengage from the scheme. They'd rather do nothing and just go underground, which is not what we want, neither for society or for people victims of the process. What we lack is very kind of tight guidance on to help people understand what is it that disqualify them and potentially put them at risk of being deported. And it is not at all clear to anyone, I will be honest.
Thank you.
You wanted to come in on this point, Andrew?
Yes, please. Thank you, Chair. I can understand, I think he's got some valid points. You want to feel secure, and that you, this is the questions for Anne, Laurie and Nicholas, that you want to feel secure in your status in the UK, and that, you're not going to be turfed out the country after Brexit. But as an organisation yourself, Nicholas and Laurie, I have to say, when I look on your Twitter and your social media, when you're using rhetorics saying, tweet entitled Brexit horror stories and other things saying, becoming the next victims of Theresa May's hostile environment, don't you think that you're actually adding to this fear of the people you actually saying you're trying to protect?
Well, we want to make sure people realise what it means if you're undocumented.
No, but do you think words like that is actually helpful?
Yes.
I think it is, because it's very hard to engage communities.
Well, I'm sorry, but if I was hearing words like that, and you talk about these vulnerable in society, it would put the fear of God into me. I really don't think you're helping. Are you trying to overturn the Brexit vote?
It has nothing to do with it. It really has nothing to do with it. That's very clear. No, and Mrs. actually...
But are you?
Okay,
no,
let me answer that. No, from the beginning, we've said that our organisation has the sole purpose of protecting our rights as
which
individuals.
Is commendable.
So we don't have on Brexit, we're Brexit neutral.
But I have to say, I'd like to put it on record, your language on social media, I personally think it's putting the fear of God into the people you're meant to be protecting.
Maybe, can I...
Okay. Right. Pat McFadden.
Thank you. I'd like to go back to our witnesses from the Irish. Catherine Hennessy, earlier in response to the chairman, you said the position of the Irish in Britain has been one that's evolved, and I think that's right. There's not been a lot of paperwork, there's been no requirement for an immigration process and so on. But we're now in a unique situation where the UK will be outside the European Union and Ireland will be inside the European Union. We've not had that before. We've had a situation where both countries were out, and we've had a situation where both countries were in. So this is new. And my question really to you is, given that informality, that evolving nature of the status of Irish people in Britain, do you see any need for legal changes here in the UK to make sure that there's no change to those people's status, which I think is the policy intent of the government? I don't think the government intends for there to be any change in the status of Irish people.
Well, I think the first thing I would say is, in response to your question, is that the provisions, as EU citizens, the provision, of course, exists for Irish people to apply for and settle status. But our intelligence suggests that the majority of Irish people will not do that, based on information about numbers of applications, say, for UK citizenship amongst Irish citizens living in Britain.
And they don't have to do that?
No, they don't have to. I think, as you quite correctly say, that when both countries were outside the EU, the common travel area, many of the agreements were based on the fact that both countries had common law and operated under common law principles. I think we would have some anxiety that without some formal statement of the position within law, it might leave Irish citizens vulnerable in the future, I guess.
But you haven't identified a specific legal change that you think the UK needs to make sure there's no change?
Not at this stage.
Can I turn to the question of people in Northern Ireland? Because they have specific citizenship rights. And the Good Friday Agreement says that people born in Northern Ireland can choose to be British or Irish or both. So anyone born in Northern Ireland can have either a British passport or an Irish passport, or indeed both, if they so wish. Again, do you think there's a need for any legislative change here to make sure that that continues to be the case after Brexit, given that Ireland will be inside and we'll be outside?
I doubt it. I suppose the one thing that we are concerned about in the community is about the Good Friday Agreement and the adherence to the peace process. I would like to think, we would like to think that every effort will be made to sustain that, and that any changes that happen might be divisive. I'm not sure is my answer to that.
I think it's not an issue we've looked into in detail, but I think we will now, following your question.
Okay, I'll leave it there.
Okay, thank you very much. Howard Williams.
Thank you, Chair. I was going to ask you about some questions about settled status and the application process, but I think those have already been answered. So I'd like to ask you some cases in point, some specific issues. For example, are you aware of any research, planning or implementation by governments to address what are called immigration advice deserts? I represent North West Wales. Typically my constituents travel to Manchester, Birmingham or London to access immigration advice. Do you know if the government are going to address those particular problems?
I think there is a big question mark around that. There is immigration advice is kind of weird area of advice. It's strictly regulated. We have our concerns about regulation and the way how is that being implemented and policed, so to speak. There are areas, rural areas pretty much anywhere, are deprived of immigration advice, and our worry is that for example, Eastern European EU nationals would be agricultural workers. They are effectively deprived from access of any advice and information. This is why we are asking for support from Her Majesty Government to make sure that every member of the EU community has access to anything, and it's not only based on digital means. It's not enough.
In the user group, they have said that some people who will need advice can call a call centre, which will be staffed by civil servants. When you ask them, will the phone number to call them, will this be a free phone number, or are we going to go into a DWD phone number fiasco? No answer. Loads of very practical forms of help like this, which could work for some people. No answer. What we would like to see is a local face-to-face, access to legal advice, legal support, but also there is no legal aid. We have to be very clear about this, except in very special circumstances. Even then, I understand from immigration lawyers, even that is a battle for them to access. So you have people who are victims of trafficking, people who are victims of rape, who dare not actually report issues to the police, and straight away they fall into the hostile environment, and they have no access to legal aid. But really, some people...
I'm going to ask you some further questions about that in a moment, if I may, Chair. That sort of thing. Can I ask you, are you aware of any efforts to reach out to very specific communities? I'm thinking, for example, of the retirement home for Polish people in the far reaches of North West Wales, Dom Polska, Cartrew, Pwyliaid, or the Polish home, where the languages, incidentally, within the home are Polish, then Welsh, and then sometimes English.
Our concern is that it kind of feels like that this is the sort of work we would have to take on. I mean, we would gladly do that. However, the question is, how is that going to be operationally done? Because it will cost some money. And it can be, and so the question is, how are we pulling in resources currently existing? So, for example, social services provision or duties that local authorities have over people, because it is impossible to believe that Her Majesty's government can imagine community taking the whole immigration scheme on its own sort of and providing this advice. It is not realistic to perform, and also within these timescales. And this is our worry, that there doesn't seem to be any constructive conversation about practicality of making it happen. So this is case in point exactly. This is exactly what what we are debating within the community. How do you make sure that those, for example, residential care, community-run institutions are covered?
Very, very same sort of problems. I mean, it was very clear. And in a way, I mean, I'm tempted to make this comment that it feels like the Home Office has never had to deal with people who have all kinds of disabilities or who are vulnerable in society, people who are currently in prisons. It's like all of a sudden, you know, they're asking NGOs to say, who are these people? How do we help them? Can you help them? But we don't know whether there is any funding to help you to do this kind of work. I mean, people with disabilities have always existed. People with all kinds of difficulties have also existed. All of a sudden, it's like the government doesn't really know what to do with these people, but they've always been there.
Can I therefore turn to a group where the government has some experience, that is people who speak more than one language, or two languages, in my case. I am familiar with the application process online for universal credits, which initially was to be available through the medium of Welsh and English, and where the provision through the medium of Welsh has been postponed repeatedly because of difficulties that the department has in dealing with two languages at once on their computer system, mainly because it's been designed to work through the medium of one. Do you have any comments on that sort of
Well, there are many
problem?
comments around that sorts of problems. I mean, you're dealing with citizens as well from 27 different EU countries, where, for instance, it's quite common in northern countries for the second name to be used as the first name, names with accents, names with hyphens, names in some countries is the maiden name, which is used as the family name, and the system says no. It's a classic case of the system rejects the applicant because we don't fit within the norm of having a British name, where there are no accents, no this, no that. I get kicked out every time I want to go online to check in because I've got a hyphen in my name, so computer says no.
On the languages, our understanding is Home Office has made a decision that the online application scheme is going to be exclusively in English, and it's kind of up to community to provide guidance on how to go about it. Now we are arriving at some understanding that it is probably not enough. However, there is no declaration of, the declaration that we've heard is that Home Office can support us with printed materials and potentially tablets to help people go through it. The workforce is not included in this support, so actual people doing it. And we don't know whether there is any funding moved onto training those statutory duty kind of carers for some more vulnerable people, because this is not something that we heard. So local authority, social services, for example.
Are you familiar with the .gov protocols as to how documents are presented online? Specifically that if there's any reference to another language, it is in small print at the bottom of the page, and unsurprisingly, most people fail to find the reference to Welsh. Do you understand that that might be the case with other languages, that one of the 27, or perhaps more than 27 languages which have some sort of official status within the rest of the European Union?
It's going to be a very complex process of translating even, because if you consider the fact that common law is British, while European legal system may be slightly different, even actual verbal translating the guidance is going to be a big minefield.
So, can I proceed, given that time is short, to a specific question about the legal status of answers given in languages other than English? And perhaps this is something that we might explore, Chair, with a government department, if we can find one which has any information about this. In that, from the experience of my own language, in 1967 there was an act which said that Welsh and English were equally valid, so that one was treated the same as the other. However, if there was a divergence between the English and Welsh texts, the English should prevail. That is, if it said in Welsh, dau a dau yn bedwar, and it said in English, 2 and 2 is 5, it's 5 rather than 4. The 93 Act says that Welsh and English have to be treated on the basis of equality. That is, basis rather than being equal. And that has led to some confusion. Now, I just wonder, has anyone explored the legal status with you the legal status of answers given in languages other than in English?
I don't think there is any facility to give answers in any other language than English. Well, possibly Welsh as well, if people choose to apply. Yes, but then again...
My former office manager is very fluent in Welsh, Danish, and sometimes speaks English as well, but I know which one she prefers. Sorry.
But also what will be needed, so say we are successful, we get settled status, we absolutely need a document that we can have in our hands, in our pockets. Because at the moment the government is talking about a digital code, which for instance a potential landlord would have to go online and check that our code is correct, it's valid, and they've been talking about using your passport numbers as the code, except that passports did change, and when they change there's a new passport number, and that's no good. I can give you an example of a landlord in Bristol. He has over 40, 50 properties. He just about has a last century mobile phone and doesn't do the internet. It's very unlikely if he sees a potential tenant turning up to visit one of his properties to go online to check. So people will be discriminated on that basis, and it's quite common.
And it's going to be the same with employment.
Employment, accessing services. We already know that EU nationals are having a really bad time applying for welfare benefits, for housing benefits, where some councils and DeXEU are asking for far more evidence of rights of residence when they shouldn't be doing that at all. It is an issue of over-compliance at the very least, or when some councils ask for proof of residence, the person provides the permanent residence card, oh, that's not good enough. Well, then what?
I mean, that goes beyond the questions that I asked you, but perhaps, Chair, as I said, we can look at some of the details that I alluded to earlier on in the further session, if possible.
Okay.
Thank you.
Thank you very much. Now, I know that together with the Open Rights Group, you're trying to launch a legal challenge to the immigration exemption from the Data Protection Act. Could you just very briefly explain to us why you think that getting information in connection with any appeals via a subject access request wouldn't give the people you represent what they need, and that therefore you require the immigration exemption to the Data Protection Act to be overturned? What would be missing?
Well, let's say first that we're very supportive of the Data Protection Act because it's a very good act, and we regret that there is this exemption for immigration data. Considering 3.6 million people will have to apply for settled status, there should be no restriction to access to data by people, and that should be done at any stage. So you're talking about procedure that you can request your data, but really, if I want to check before making the settled status application what's my data with the Home Office to see if there's any mistakes, I should be able to do so. The Home Office could use the exception to stop my request at that stage.
But why wouldn't you be able, anyone applying, not be able to get that by means of a subject access request? I'm just trying to understand what is it that could be held back under the immigration exemption that wouldn't be provided by a straightforward subject access request.
Well, we understand that the exemption will be used case by case.
Right.
So it's not clear how they would apply the exception, but because the exception exists, it does worry people that they won't have full access, and they will be used against their own case to cover up mistakes if there are mistakes.
Okay, that's very helpful. Now, just going back to the point about older EU citizens who don't have any paperwork, have you received any assurance at all from Home Office officials as to how they propose to deal with that? Because if you think of someone who's living with their children, isn't on the council tax, never worked, doesn't have a national insurance number, isn't on the insurance policy, basically has nothing apart from the word of the son and daughter-in-law or whatever that they're living with, that they have been here for X number of years. What has the Home Office said to you in the discussions that you have had? And by the way, if I could say to Mr Gianogli, we have invited a Home Office Minister and officials to come and give evidence to us, and since this is a public occasion, can I say I look forward to getting a reply so we can take that evidence. But have you had any reassurance?
Not really. What they said is that, especially with regard to people who, probably these people who, older people, people with vulnerabilities, who may not apply in time, they're talking about grounds of reasonableness. But when you push them, what do you mean by that? No answer. It will be a case. It will be dealt with by the caseworkers who can use discretion. To me, that's too vague. We need to know, as I say, we need to have parameters so that we know exactly how we're going to be assessed and how those people who don't, for instance, can not in a position to provide the sort of documents that they are proposing to use. They've produced a hierarchy of documents which are not so dissimilar to the one for permanent residents. If these people are not able to produce those documents at the discretion of the caseworker. But some people might not even pass stage 1. Some people don't have any IDs for all kinds of reasons. Some just don't. They have chaotic lives. They don't. Or some people are estranged from a violent spouse and have nothing left. Some people have lost everything through being homeless. Then it becomes really difficult to try and find means and ways of supporting them.
I think the only security sort of safeguard we have for this particular group would be to apply as a dependent to family existing. So it applies to parents, children, or close sort of family. Now it applies to people who live with their families. Now our worry is about people who are isolated. Yeah. Because this is where this mechanism doesn't just plainly work.
If you were living with your family, your son or daughter could say, I hereby declare that
yes.
My mum has been living with us for the last 7 years, and by the way, here's the evidence that I've been living here for 20 years, or whatever it is.
That is not that simple, actually, because their right as dependent is dependent on the residence evidence of their...
Well, indeed, but in the circumstances in which they can't provide them some evidence...
Yes, I mean, technically speaking, there is a road.
way will need to have to be found to make sure that people are treated fairly. And that would be one approach that you might suggest.
Yes, but it's quite clear from the list of evidence that they want to see. It has to be in the person's name and not in somebody else's name. And I came across the wife of a farmer in Devon. She had been in Devon and in the UK for 12, 15 years. Nothing at all is in her name. She's never used GP, never used a dentist. All the bills, absolutely all the paperwork is in her husband's name, which is actually quite common in small businesses, family businesses. So what does she do? She's not in a position to apply for anything. She has no footprint, basically.
With this particular immigration scheme, the Home Office is trying to simplify it in a way that, so for example, I would apply, my individual application number would be then used by my dependents, and therefore this person is completely dependent on my evidence. Now, it is complicated even when I'm saying this, and we have tried through the outreach events we have been organizing with members of Eastern European Community to run it through to see what people understand. They don't at all, quite frankly, because it is becoming quite complicated which number falls where and who is effectively becoming dependent on who. So there is a road that just needs to be very thoroughly explained, and care has to be taken of people who are isolated.
And finally, and very quickly, you've made reference to your concern that in the absence of any deal at all, what would happen to the rights of EU citizens, and the proposal for ring-fencing of this agreement separately, whatever happens. Have you received any assurance from ministers or Home Office officials that you have spoken to that that is what the government would do? Have they committed to do that in the event of no deal? Have you received such an assurance?
No. There's been no assurance at all.
No assurance.
I mean, this is the worst-case scenario for EU citizens, because on the 29th of March, you get 3 million illegal immigrants in the country as a result, because we won't have a status. So we've got no assurance at all. I think maybe the conversation, we've tried to introduce the conversation over the last 12 months. Maybe it was too early. If it becomes more of a possibility, maybe then, but it might be too late to provide a status that will protect us in that case.
So, presumably, and very simply, you would welcome such an assurance being given?
Yes.
You would? Okay.
And this is something we have asked from the very beginning.
Yeah. Yes, indeed. Well, can I, on behalf of the committee, thank all of you very much for coming today. Your evidence has been extremely helpful. And we'll now move on to our second panel. Thank you. No, because I'll bring you in. Well, can I welcome our second panel this morning? Thank you very much for giving up your time to come and give evidence to the committee this morning, and in particular, Calba Meadows, founder Remain in France Together, Fiona Godfrey, Chair of British Immigrants Living in Luxembourg and Deputy Chair of British in Europe, Jane Golding, Co-Chair, British in Germany and Chair of British in Europe, and Michael Harris, Chair of Euro Citizens in Spain. Thank you very much for coming today. Jonathan Ginogly.
Thank you, Chairman. Just to have a look at the situation for British nationals living in the EU, if I may. About a week ago, there was a report that approximately 10 countries were likely to introduce a system for UK nationals in their territory that was similar to that planned for EU nationals in the UK. And it seems as though a number of countries have expressed a view that imposing an additional mandatory system on British nationals in their country would prove an unnecessary complication and expense. So reports coming in from various places. And I suppose my question is, have you seen any evidence of how individual EU 27 countries are preparing to manage British nationals residing in their territory after the UK leaves the EU? Perhaps Ms Meadows first.
Do you want to? I'll pass this one over and then I'll come back to the specific situation in France, if I may.
So thank you very much for the question and for the invitation to address the committee. I'd just like to start by saying that Jane Golding and I have just come back from spending 2 days in Brussels, and we've had a series of meetings with the three main institutions, the Commission, the Parliament and the Council. This question came up. Registration of British nationals living in the EU is a key concern for us. So the first point to say is that mandatory registration already exists in most of the EU member states. France is one of the exceptions. So the member states where we are currently living, they know who we are, they know where we are, and they know how long we've been there. So the prospect of introducing settled status for us only came up in the joint agreement that was reached in December. Up until that point in time, it hadn't been on the table. So we have been making representations to our member states, and we have been asking for them to continue with the declaratory system based on the 2004 Citizenship Directive, which currently regulates how we are registered and how we live in our host member states. So we had some discussions in Brussels on Monday and Tuesday about this. We understand that it's true there is a majority of member states that wish to continue with the declaratory system. And I think it's an important piece of background here that for the EU 27, the British community in their member states, we're not a political problem, we're just an administrative problem. They want to be able to ensure that they can recognise that we are part of the group covered by the withdrawal agreement should we eventually get one. So our intelligence at the moment is that most member states are intending to apply the declaratory system, but we don't have any clarity on that point as of yet, and we won't have any clarity until at least the autumn. And one point that did come out in our discussions is that the member states and the European Parliament are intensely aware of what is happening over here. They do read the press, they do follow the political situation here, they're well aware of Windrush, they're well aware of EU citizens being deported, and ultimately our fate will rest in the hands of, to some extent, the UK government and the Home Office, because the EU 27, whilst they've made it clear that they do not believe that we are in any way responsible for the situation we find ourselves in, they accept that approximately 60% of us were disenfranchised in the vote. They want to make sure that their own citizens are well protected here. So the Home Office needs to sort out its system, it needs to get the application up and running, and it needs to be working, and people here, our 3 million colleagues, need to be protected.
Thank you very much.
Thank you.
Mr. Harris.
Yeah, I'd say there are 300,000 Britons registered in Spain. And I think one of the problems is that there's a lot of stereotypes about us. When people think about Britons in Spain, they think about as a wealthy retiree sitting around a swimming pool drinking gin and tonics. And that's what you see when the newspapers talk about us. And 2/3 of the people in Spain are working age or below. And out of the pensioners there are a lot of very, very vulnerable, very poor people on minimum pension, and there are people also working as with low wages in 0 hours contracts. All kinds of things are happening. And there are also people who aren't registered. And one of the things that the Foreign Office is trying to do in Spain is to try and get people registered, because there is a registration system in Spain, and once you're on it, that should make things a lot easier. But there are these vulnerable groups who are not on it. There are also a lot of people who spend several months a year in Spain, and probably they're not so aware of the need to register. They're called the swallows. They go there in the autumn and come back in the spring. And there are large numbers of people basically out there. And as we were talking about with the EU citizens in the UK, there are these vulnerable groups. And I'll hand over to Calba here in France, who's also very well aware of this in France.
Yes, I'd like to talk a little bit about the specific situation in France. France is an anomaly in that it's the only EU 27 state that doesn't have any current registration system. British citizens can currently move to France, not even required to report their presence, let alone register. So we have a population, conservative estimates 150,000, probably in reality very much more than that. And just to tell you a very little bit about who we are, we're a very rural population. We're scattered over a very wide area. Most people live far from other British people, in fact. We don't have huge diaspora in one place. So contact between British citizens is infrequent, and there are no big communities. Some areas have more, some areas have less, some areas have almost none. Most people, as in everywhere else across the EU, most people are working. Again, coming back to the fact that we are an essentially rural population, most people are doing very, very kind of low-key jobs. We have a lot of tradespeople, craftspeople, people working in factories, people working in shops, people working in bars, people with small tourist industries. So we're talking about low incomes here. We're talking about people who are just about managing, and some, I have to say, are not even managing. So that perhaps puts things into context. Because there's been no requirement to register, most of our group have no real experience of being in touch with administrative authorities in France. And there is a very, very big fear about doing that. They don't know how to do it, they don't know where to go, they don't know what to do. Currently, my group, which has nearly 8,000 members, is spending an enormous amount of time fielding questions and inquiries and just dealing with general fear about what will happen in future. It's a fairly foregone conclusion that whether we have a declaratory or a constitutive system in France, some kind of registration will be necessary to prove our rights as part of the protected group under the withdrawal agreement. So it's very unlikely that we could go on as we are now with no documentation at all, because there would be nothing to separate us from British who come along in the future after the end of transition. So we're talking about a very large group of people who are going to have to go through some form of registration system. And we don't know what that's going to be. And that is causing the most enormous amount of anxiety and stress. Just to give you some figures, in the last 28 days, the social media part of my group, which operates via Facebook, has dealt with 40,000 questions, comments and inquiries simply about citizens' rights issues. Now that is phenomenal. We are run by volunteers. We have no funding. Our citizens' rights team are working evenings, weekends, through the day, almost 24/7, dealing with inquiries from our members. Now, we're not unique. This kind of thing is happening all the way across the EU. I'm not saying we're a special case, but it gives you an example of the level of fear and anxiety. And uncertainty is the killer. Not knowing how we're going to be required to register, not knowing what hoops we're going to have to jump through, not knowing whether we're going to have to apply for our status. And if we do, there may well be people in our vulnerable groups, which I hope to talk about if there's time, who may not meet the criteria. And that's another level of uncertainty. It's another layer of limbo.
Sorry, can I just ask that? How responsive are the French authorities to your request, and are they helping you?
Let me just say it's at a very early stage.
Right.
One of the difficulties with French administration is that it's decentralised. So we have 95 offices dealing with registration. Each one of them operates a slightly different system. Each one of them requires slightly different documents. So although there is general advice from the ministry, not every registration office interprets it and applies it in the same way. So because we have so many levels of uncertainty and so many levels of the unknown, very many people just can't cope with it. I'll be perfectly honest. And when you've got that level of stress and uncertainty, many people stick their heads in the sand because they don't know how else to act. Actually, we're facing a ticking time bomb here.
Okay. Yes, very quickly. I mean, on the point about the uncertainty and whether the French authorities are doing anything at the moment, I think it's fair to say that the EU 27, obviously at the moment, there is only so much that they can do, because the draft withdrawal agreement is not finalised. It is not a legally binding agreement. It's only a political agreement. And so I think the authorities, they're trying to do what they can, and they're in preparedness mode, but there's nothing clear yet that they can implement, because there is no certainty for the two groups, because there's no legally binding agreement as yet.
Right. Okay. Thank you.
Right, Mr. Gray.
I wasn't expecting to come this way, Chairman. I'm very happy.
Oh, sorry, I
just
thought
to ask one question, really, in general, and in a sense, it's irrelevant because dealing with uncertainty is all about the fear of the unknown. But are you all aware that the original British government starting point in these negotiations was to deal with the issues of citizens' rights separately and first and legally bindingly before anything else, and that was rejected by the European Union?
We are all aware of that, and we understand exactly why that approach was taken on the EU side. Until Article 50 was triggered, the process of negotiation hadn't started. And I completely understand Frau Merkel's approach that only once the negotiations had started could this be dealt with. But it was clear on both sides at that point, once the negotiations start, that citizens' rights was one of 3 priorities. But we are where we are now, and we still haven't got a finally legally binding agreement. And this
but
was
it is
supposed to
important
be
for British citizens living in Europe to be absolutely clear that we wanted to deal with that at the beginning. It was the European Union who insisted on these 3 issues being treated together, and with the phrase that nothing is agreed until everything is agreed. You're quite right. It's irrelevant in the sense to dealing with the uncertainty where we all are now, but it is important, I think, that everybody understands that their government, our government, was actually trying to deal with all of this right at the beginning. And therefore that does put, to some extent, the emphasis back on the host governments of the countries where our citizens are living in Europe to try and respond to the varying different degrees of uncertainty, because whereas European nationals here are all dealing simply with one government, ours in Europe are dealing with all 27, and quite possibly with different regional variations in terms of applications and so on. So do we have a complete, does the group have a complete analysis of exactly what the situation is in all 27 of the European countries where our citizens are living?
We don't have a complete analysis. We did a very quick survey of our membership last month now. We had over 2,000 responses, and we asked a basic set of questions, including, people's opinions on the general process that they have to go through. In what status did they register, as an active or a non-active? Was their application successful? Did they try and register a non-EU family member? And the costs and travelling times, and generally people responded that they are happy with the current registration system operating in the EU 27, which is mandated by the directive.
How many of the countries are in the same situation as France, and indeed ourselves, where you don't have to register at all currently?
France and Ireland seem to be the only countries where that doesn't apply.
Right. Yeah. Okay. So in terms of submitting written evidence on what your understanding of the situation is in all 27 of those countries, is there a document or a particular summary of that which we can access, which will be very useful when we're talking with government?
We've got the survey results that we carried out, but the number of respondents, apart from France, wasn't statistically significant, so it's of anecdotal value. We share perhaps your opinion that there is a need for a very, very detailed piece of analysis. We would be very happy if the British government would commission that piece of analysis. We've done what we can, but we're all volunteers, and as Calva said, we have no funding, so we would very much welcome research of that kind.
And when you visited Brussels to see the 3 different European organisations, what did you understand from them in terms of decisions that the EU will be making on the future status of British citizens in European countries, and what will be the role of national, possibly even below that, regional governments?
This is a decision that's been made. I mean, the status of British citizens in the EU falls under the withdrawal agreement, so it's a matter of EU competence. But of course, once the withdrawal agreement is in place and the detail is legally binding, that has to be implemented at national, regional and local level, which should not be forgotten.
What we've heard, for example, from our meetings in Brussels, is that actually it's part of the national powers or competences, in Europe speak, that the business of registrations and applications and so on is entirely decided nationally. So what are you expecting at the top level the European Union to decide?
Well, that isn't actually our information, because the registration procedures that exist now in the EU 27 are based on the 2004 Citizenship Directive, which is sets out very clearly what the rules are on registration before 3 months, after 3 months, and also applying for an optional card which evidences permanent residence.
You've just said that France and Ireland doesn't require a registration
That's right,
system
because
at
there
all
are
at the
options in the Citizenship Directive
and
whether to require them.
Presumably within the other 25 there are considerable differences in the actual application form and how they're treated and who they go to and all the rest of it.
Yes, indeed. I mean, there are practical differences on the ground. So if I give the example of Germany, where I live, it's really quite straightforward. When you arrive in the country, you have to register within the 3 months. So everybody is clearly registered from the beginning, and the Germans know exactly when we arrived. We get no actual card. All we get is a document that shows that we've registered, but not a card that we take around with us. And if we want a permanent residence document, that's optional. We apply for it.
And are you expecting any changes in the current arrangements, whether in Germany or elsewhere?
This is for a finite group of people, and we're talking here in most countries maximum in terms of hundreds of thousands, and in some countries less than 100,000. It's 107,000 British nationals, for example, in Germany. We don't expect that the EU 27 will therefore wish to introduce entirely new systems when they have a registration system in place already. And what we have been pushing for is a simple extension of the existing registration systems.
And have the Germans confirmed that's what they intend to do?
At the moment, there was a workshop of all EU 27 members with the Commission and Council on the 25th of May to discuss this very question. At the moment, it is still being discussed at EU level, and you have seen probably the Guardian article where some information from that meeting was leaked as to whether a majority of the EU 27 are going to stick with existing systems, and that there are possibly 10 countries looking at introducing new systems.
Do you feel you're being used as a hostage by the European Union in the negotiations?
I think they're being used as a hostage by both sides, actually, and because, you know, citizens, on both European citizens and Britons in Europe, at the beginning, both May and Barnier said all our rights would be guaranteed, but it didn't take very long for us to become bargaining chips. I mean, that's how our members feel. Our members are very angry. Not only they're angry actually with both sides at the moment, with the UK government, who we feel are not defending our rights. You know, they're not bringing to the table the issue of freedom of movement, which is one of the key issues that affects British in Europe, that we lose our freedom of movement. We'll only be in one host country. And the British government hasn't brought that to the table since December, and that's our key issue. The European Union, the European Union as well. We had a round table in Madrid 3 or 4 weeks ago, and there was a representative of the European Commission, and he got a lot of stick because he was saying also that citizens' rights were guaranteed. And the British government is also saying, well, citizens' rights are guaranteed, they've been safeguarded. If you look at the Foreign Office website, it says, you know, that the deal has been done, the citizens' rights are guaranteed, you've got nothing to worry about. And the European Union is saying the same. So we feel that we're hostages of both sides, we aren't getting much support. We're not getting much support amongst MPs. We're getting more support actually in the European Parliament, who are actually, have put one of the red lines for approving the withdrawal agreement as freedom of movement for Britons in Europe. Yeah. So they are really the ones who are doing that. I think the 1.2 million Britons, which is the size of the population of Birmingham, we really feel forgotten, actually, and there's a lot of frustration, uncertainty and anger, because, as well, as it's been pointed out, a lot of us couldn't vote in the referendum to start with.
Yeah.
So we do really feel victims in this situation.
I think it's a perfectly valid point. Have you had any opportunity to make those points to the British media here, who tend to spend the vast majority of what they write about is concerned with the rights of European nationals here in the UK, which is extremely important, but actually your rights are equally important, and we're here to represent you first and primarily. Have you had any take-up from the British media in terms of putting these views over, particularly on the right of being able to move from one to another country in Europe?
We have tried very hard to raise our profile in the British media. It is quite an uphill struggle. We are not of great interest to the British media. We have had some interviews on Sky, on BBC, but it's very, very difficult to get our views heard in the British media. The Guardian has been very supportive, but that is a...
And how many, roughly, do you think of the 1.2 million British citizens living in the European Union have got links or residences or some attachment to a constituency in the UK? And you can see where I'm leading to, is to what extent they've actually contacted their MP to try and stand up for them. Because I haven't been contacted, I think, by anyone who has a link to my constituency.
We've had a number of very big lobbying exercises that have been taken by our member groups. I'm sure a number of people here will have had letters from our members. And we get some responses for which we're very grateful.
Yeah.
But I have to say, I don't feel personally confident from either the number of responses that we get or from the level of total understanding shown in those responses that every MP understands the issues facing their constituents. Not only that, I think we're very often regarded as of lesser importance to MPs because we're not living in the UK. And somehow, although some of us are still just about constituents and still just about able to vote, the vast majority of us have lost our voting rights. And therefore we are not represented.
Indeed. Now, John Whittingdale wanted to thank you.
I just have a small question on this point. I absolutely want British citizens living in other European Union countries present to continue to have the right to remain there. And that is something we're all agreed on. But on the question of free movement, I'm not quite sure why a British citizen living in France should have free movement around the European Union when a British citizen living in Britain won't.
I think the point is here is that what we're talking about is a very finite group of people who've actually exercised their rights of free movement and have moved from the UK to the EU 27. And I think one of the facts about this population that's often overlooked, particularly by the tabloids here in the UK, is that actually nearly 80% of us are working people. And the way that the working world works today is that, for example, I have lived and worked through my career in 5 different EU countries.
But just because you have decided to move to another European Union country, you are still a British citizen.
Yes.
And therefore, surely you should have the same rights and also not have additional rights to other British citizens.
But we have had these rights and we have exercised these rights, and under EU law and EU case law, that therefore means we've activated rights which would then be removed from us. That is, I think that's the point. There's a difference under EU case law between somebody who has stayed in the UK and never exercised their rights and somebody who has moved to another EU country. But the other point really is that people have moved in good faith with a legitimate expectation that they had these rights, and they've based lives and livelihoods on them.
But nobody is suggesting that they should not continue to have the right. My point is that I would find it difficult to argue why my constituents will not have the right of free movement around Europe after we leave the European Union, but British citizens who've decided to go and live in France should still have.
I think the point here is I represent a group from Luxembourg, which, if you've ever been, you will appreciate is a very small country. You can cross it in 20 minutes. So, you know, if I need to buy a set of shelves from a well-known Swedish furniture chain, I have to go over the border into Belgium. If we need healthcare, we frequently get referred to centres in Germany or France or Belgium because that's where the specialist centres are. If you have moved over the Channel as a British citizen, you are part of a very mobile population. Many of us have non-British spouses, so we have family members in other EU 27 member states. Many of us have children who are studying or who are intending to study, not in their host member state, but in another EU 27 member state. It could be the UK for now, or it could be, you know, a French child with British parents studying in the Netherlands. We exercise our free movement rights. We didn't move to one country, we moved to the territory of the EU 27. And we've built careers and we've built lives and families and relationships on that basis. My job is I'm a self-employed cross-border supplier of services. I live in Luxembourg, I work there, but I also work every week in Belgium. And often I will work in another EEA member state. Next week I'm in Oslo and Brussels as well as Luxembourg for my day job. I have lived and worked over the last 20 years in every single EU member state, plus Switzerland, plus Norway. So we're a really mobile population, and for us free movement isn't a nice to have, it's an absolutely essential to have. We need it to maintain our family relationships and we need it to maintain our livelihoods. And when we moved in the expectation that that would continue to be the case.
But I can identify a dozen people immediately who are living in the UK who are just as mobile around the European Union as you are. They have chosen not to go and live permanently in France, but they are just as mobile in terms of going and doing business in different European Union countries. I'm confident that they will continue to be able to do so. But I still don't see why you should have additional rights to them.
Because we've exercised our rights. We are a finite group.
And the other thing is that when this all started, that politicians made it very clear, May and Barnier has made it very clear, that our existing rights will be guaranteed. And these are our existing rights. These are the existing rights that we exercise and have exercised for years. And I think that's, you know, this was talked about, this finite group of people, Britons in Europe, was mentioned and was talked about. And these guarantees, these promises were made, and of course the whole thing of freedom of movement has been taken away. And it's the arguments, obviously, it's you know, as Jane and Fiona pointed out, it is different if you're living in a country and you haven't gone around and you haven't done that. As someone living in Luxembourg, I mean, it's horrific. I mean, I live in Spain. I can go to the Balearic Islands, I can go to the Canaries, I can go, you know, it's a big host country. So, but, you know, the situation of Benelux is you know, is impossible.
Okay. All right, thank you very much. Now, Vera Hophouse also wanted to come in on this point, and then I'll turn to Pat McFadden.
So the beauty of free movement actually also applies to British citizens, and there might be some British citizens who are also going to be very disappointed that that right of free movement is going to be taken away from them. But what do you... And the interesting thing is actually whether we can treat British citizens differently, the ones who are here and the British citizens who are living abroad, so whether you ultimately legally will end up with a different legal status. But what is it that you think the European Union countries are putting in the way of allowing that, and in which way could we, as you know, MPs, put government under pressure to make progress, and what is it we should suggest? So what is it? Why are the European countries seem to be using you as a bargaining chip in that?
I think that all that needs to happen is for the question of continuing free movement to be put back on the table. I mean, the intelligence that we're getting, we are meeting at EU level, as we've already said. We've been in Brussels the last couple of days, and we've been meeting regularly with the Commission, the Council and the Parliament, the European Parliament in Brussels. But we've also been talking to officials and politicians in the states where we actually reside. And the intelligence that we're getting is that the issue of continuing free movement for citizens covered by the withdrawal agreement has not been officially put on the table since December. And there was surprise, I think, from the EU side about this.
And you mean that's the British government who doesn't put it on the table? So
and
it would be
until
for
it's
us.
put on the table, there will be no response. And what we've understood as well from talking through our contacts is this is not actually a red line for the EU 27.
Okay, thank you.
It's winnable.
We could get this in the withdrawal agreement in October if the British government will make the request at the highest levels.
Well, just very quickly, because you've had a...
Are you saying that you believe, from what you hear in Brussels, that the British government is still open to the suggestion of retaining free movement of people?
We're hearing that the member states, the EU 27, are still willing to consider putting continuing free movement for us in the withdrawal agreement in October, but for that to happen they need the British government to make that request on our behalf, and not at a technical level, at a political level.
Free movement for the Britons living in Europe at the moment?
Yes, British in Europe.
Yes, the EU 27.
Yeah, that is clearly, very clearly got to be a negotiating objective, there's no doubt about it. The only question, you will understand, is at what stage, if you like, that is used and how it's used, because there will be all sorts of requests on the other side. But that is, I mean, in my view, and in this committee's view, I think we're fair to say, I mean, that is absolutely a crucial outcome for all of you living in Europe.
Now, Stephen, did you want to come in on this specific point, and then I'm going to go to Pat, all right?
Coming back to Fiona Godfrey's point about living in Luxembourg, presumably there are US citizens living in Luxembourg who are in exactly the position that you described. They've got to go to health treatment elsewhere. How do things work for them?
I'm not an American citizen, so I can't answer your question. It's covered by it's covered under EU third country national legislation, but what we do know is that the EU third country national immigration regime is nowhere near as beneficial as the current EU citizenship rights are that we currently enjoy. There are provisions which make it possible, but they don't add up to what we have at the moment. So we would very much like to retain as many of the rights that we currently have as EU citizens through the withdrawal agreement.
Can I just come in there? And we've looked at this question of how third country national legislation could apply to UK citizens living in the EU 27 quite extensively, because obviously we do have to contemplate the possibility of a no deal, and we have talked to the Commission about this, including the department that is directly responsible for it. That obviously in terms of visa-free travel there are far more limitations. I mean, we have a right of free movement. We have no limitations on the number of days we can travel. In the Schengen area normally you can travel 90 out of 180 days. There are a range of different pieces of legislation. There is a possibility for example, US nationals, third country nationals, to apply for a form of permanent residence after 5 years. This is under the Long-Term Residence Directive. The conditions are far more stringent and in no way compare with being an EU citizen, and there is no right of free movement. There's a limited form of mobility. And then there are very big holes in this third country national regime as far as self-employed people are concerned. There are a number of pieces of legislation that cover employees, but far less for self-employed people who are providing cross-border services. There are very big holes there.
Okay.
Can I say something about to answer the reply?
Just very quickly.
Because you mentioned the thing about US citizens, and I think the key point here is that we have built our lives within the existing framework, and in terms of work, in terms of family, and this affects. The other thing of freedom of movement is family. For example, a friend of mine lives in Spain, and his eldest daughter lives in Malta. Now, in that situation, they will not be able to go and live with their daughter, and their daughter won't be able to go and live with them to look after them. So there are a lot of family reunification issues about freedom of movement as well within the European Union. That doesn't happen for an EU citizen in the sense that Scotland, Wales, whatever, there's not going to be an issue if that was the case. So that as well as jobs, we're also talking about family reunification. Also, we won't be able to come back with Spanish family. We'll have difficulties bringing our families back to live in Britain.
Okay, Pat McFadden.
Thank you. Just on this ongoing freedom of movement issue, the British government has made it a very early red line that it wants to end free movement. It's probably one of the principal justifications it has for pursuing its Brexit policy. But you believe that the British government can stick to that red line and also ask that the ongoing free movement rights that you have, and the Luxembourg example is probably the best one of people crisscrossing every day to live and work, should also be asked for and will be granted in the negotiations. You think both those things can hold?
Well, we think that the UK government believes that that is possible because the UK government put an offer on the table last year in September of continuing free movement in return, and this is very important, lifelong right of return for EU citizens to the UK, which is what would guarantee genuine free movement for EU citizens in the UK going forward. So that offer was put on the table by the UK government last September.
Okay, thank you. Yeah, sure.
What we're talking about here is not just politics, we're talking about human beings, and we're talking about human lives. And those lives are not simple, and they're not straightforward, and they're not black and white. They are all shades of grey. And we have to have some kind of agreement that will allow us to use the oft-repeated rhetoric to live our lives as before. And without continuing freedom of movement, we're not going to be able to do that.
Okay. Can I turn to the point that you've made, Mr. Harris and Ms. Golding? You've made the point that contrary to the stereotype, we should remember that I think you said about 80% of
79, more than 79%,
UK citizens abroad are working, which brings us to the point of recognition of qualifications. I don't know which along the row is best to answer this, but what is it that you want to see about mutual recognition of qualifications in any future agreement?
Well, ideally, the system would continue as it does now. I mean, I've, as I mentioned, worked in 5 different countries. My legal qualification has been recognised in each of those countries. I didn't need to go through national recognition procedures because there is a system at EU level recognising qualifications. So, for example, if you're living in Germany now, working as a doctor with a British doctor's qualification, under the draft withdrawal agreement, you would be able to continue to work in Germany as a doctor post post-Brexit, post-end of transition, but you would not then have an automatic right to have your qualification recognised in the rest of the EU 27. And this is a big problem for mobile workers.
So it's
and
related
we're not just,
to the free movement point?
It's very much interlinked to the free movement point. And here, as I said, I've worked in 5 different countries, but I've worked for sustained periods in each of those countries. Now, what we're seeing among the millennials in our group, and I should also point out that nearly 1/3 of the population, the British population in the EU 27, is between 30 and 49. They are not just moving from country to country for sustained periods of time. They're moving from country to country, often from year to year, because that is the nature of work. This is perhaps freelancers, people working in the computer industry. Some people are moving from country to country within 1 year.
Could you just say a little bit more for our own information and guidance about how deep this mutual recognition of qualifications is in the current system, about how it works, just to help our understanding? I mean, you say you don't want it to change, but certainly to help my understanding how exactly this works at the moment.
Well, it's a very complex system, which I probably can't explain in 5 minutes. But there are some qualifications which are automatically recognised. For example, a doctor's qualification. Right. There are other qualifications where you have to go through a certain recognition procedure and perhaps some sort of equivalence procedure, possibly some testing. I mean, there are different layers. Then there's a whole special directive for lawyers' qualifications. But it is a system which works throughout the EU 27 and which facilitates the recognition of your qualifications to a very large degree compared to what you have to go through if you have to get your qualification recognised under national rules.
And your point to us today would be these two things run in tandem, that if we're, as a government, if our government's going to ask for ongoing free movement rights, then they have to also secure ongoing recognition of qualifications, because that's what you need to be able to work. Ideally,
because yes, if your qualification is not recognised, then obviously you can't work.
Okay, thank you.
All right, thank you very much. Stephen Kinnock.
Thank you very much, Chair, and good morning, everyone. I just was wanting to go back to something that I think a number of the panellists said earlier, which is that the intelligence that you're getting from the European Union, and I assume by that you mean both the EU institutions and some of the member state governments that you're in touch with, is that they would welcome a request from the British government to, in essence, have a continuation of the status quo for those who are currently in the position of needing free movement across the European Union. And that you said, I think Ms. Golding, you said that that is not a red line for the EU. But is it right that the EU would, of course, assume then that that would be on a reciprocal basis? So EU citizens in the offer from the UK government would have to also be based on the continuation of the status quo for EU citizens in the UK.
Our understanding, I mean, the message we're getting is, I wouldn't go so far perhaps as using the word welcome, but the message we're getting is that the offer that was put on the table in September needs to be raised again, otherwise there'll be no response on continuing free movement. And yes, it would have to be on the basis of reciprocity, but we understand, I mean, the UK government put lifelong right of return on the table back in September. We don't believe that from talking to people here in the UK that the UK government has a red line about that, obviously, because the offer was put on the table in September.
I think just to come in very briefly, I think the important point to note is that that is a red line in for the European Parliament to give their agreement to the withdrawal agreement. They've made it very clear now in 2 or 3 different resolutions that continuing freedom of movement for British in Europe must be part of the final withdrawal agreement. So
yes,
that's another opportunity for this to happen.
Yeah. And you have conveyed this point clearly to the British government. And what response have you had to that?
I think we've raised it repeatedly this year, and I think the response, the most recent we've had indirectly is, I raised this point when I gave an interview to the BBC a couple of weeks ago. They went and asked for a response from DeXEU, and DeXEU effectively said that they see this as being something for the future relationship, and of course they have not yet put their proposal for the future relationship on the table.
For the future relationship beyond the transition period?
Yeah.
Okay, so that's the official position of the British government now, that this is not going to be on the table within the withdrawal agreement.
As reported by the BBC via an email that they obtained from DeXEU.
Okay, that's interesting. One other question I had, which was on the extent to which a new arrangement for the future relationship and for those who are coming into the category of the post-Brexit people that are moving around, so it's obviously a slightly different situation. What's your understanding of the extent to which a consistent EU-wide deal could be done for British citizens who are moving around the EU on that basis? Because, of course, my understanding is that this legislation is based on directives. And directives, generally speaking, the EU sets a framework in a directive, but that directive is then transposed according to the idiosyncrasies of each member state's legislation. But would you be looking here for something which was actually more along the lines of a regulation, which is actually where it's one clear and consistent approach right through the EU? I'm just recalling on your legal expertise a bit here in terms of to what extent do you think it would be possible to have one clear carbon copy across all of the member states, or do you think there will have to be some differences according to each of the member states?
I think, yes, it's possible to have one clear carbon copy, and that would have to be in the withdrawal agreement. And there would, similarly to the points that our colleagues from the 3 million were raising about the detail that's necessary in the withdrawal agreement to make clear what will happen in terms of the registration system here in the UK, a similar amount of detail would be necessary in the withdrawal agreement, which will be a treaty. It will have the force of international law and will also have direct effect. So we would then, therefore, even if it were implemented by secondary legislation in the countries of residence, we would still be able to go back to the withdrawal agreement and bring, for example, if there were a problem with implementation at national level, we would be able to go before the European Court and rely on our rights directly under the withdrawal agreement.
So bottom line is it's vital that all of this goes into the withdrawal agreement,
yes,
not into the political declaration.
Exactly, yes.
That's very clear.
Yes.
Thank you.
Yes.
Can I just add something that
I think one of the important things we haven't mentioned is citizenship and nationality. Because a lot of people say to us, well, why don't you just get citizenship? Why don't you just get nationality? And within Britain, if you have permanent residence, indefinite leave to stay, it's a relatively straightforward thing to get nationality. Now, in the EU 27, there are various countries that don't have dual nationality. I'm in one of them. Spain doesn't have dual nationality. We've spoken to this about with the Spanish ex-Spanish Foreign Minister Dastis. And Spaniards here can have dual nationality, but Britons in Spain cannot. And every government, every state has its own regulation. In Spain there is no dual nationality, though you can actually keep 2 passports, which is a highly irregular situation. You can get away with it, but we're trying to, and there's a campaign that we're starting to try and get dual nationality. There are a whole load of bilateral issues. And nationality and voting, local voting rights are also bilateral. They're not in the EU negotiations because each country has their own rules. And Britain, the British government really needs to start working on that. For example, for the people in Spain, dual nationality is you can't have it. Some people will have to renounce their nationality because if they are civil servants. And you can only be a civil servant if you're an EU citizen. So your job will go unless you get Spanish nationality. Therefore, you will have to renounce your British nationality, and that's something people don't want to do. But if it means losing their job, well, that they'll have to. So these issues like dual nationality in various countries and voting rights, there are 300,000 people in Spain. There are whole communities with large numbers of Britons. There's a town in Almeria. I was in Almeria last week, and there's a town called Arboleas, which has 75% of the population is British. And it's not a posh coastal town. It's a little town up in the mountains. And not only will we all be disenfranchised, we won't be able to vote anywhere. So we will be serfs, basically. We will have no political rights whatsoever. We'll have to pay tax, we'll have all the obligations with no possibility to vote anywhere. And in Arboleas, this town, the whole community will be disenfranchised. So 75% of the population, the only people who will be able to vote are the remaining 25%. And this is an issue that the British government, really needs to start talking to EU countries about.
Thank you very much.
Well, just hang on a minute. Howard.
Yeah, just very briefly, questions to Carla Meadows really about DeXEU, the residence cards. I saw from your evidence that it's not very straightforward in some places, very straightforward, and just a matter of a postal application in others. Can you just, for the record, tell us, how does it vary from region to region?
How does it vary? How long have we got? Applications vary hugely. They vary. Some are done by post. Most are done in person. Some require appointments. Some don't. In some regions, people have to present themselves at the registration office and may have to wait 5 or 6 hours in a queue, with many, many other residents from not just the EU, but right across the world. And the procedures are not clear. And I think one of the big issues here is, well, there are two issues. One is there isn't sufficient information given about what the procedures are because there hasn't been the history of it being necessary. But the other issue is of support. And as you've raised this, I'd like to kind of come in on the back of that and say there really needs to be in future some serious thought given to how British citizens right across the EU are going to be supported through the process of registration and, if you like, securing their residence in future years. Right now, as you've heard from all of us, it's largely being done by voluntary groups such as ours with no funding. That's a situation that can't go on. We are aware that embassies across the EU 27 now have 5 extra members of staff who have been given specific responsibility for supporting citizens. That simply isn't enough. We are going to need an awful lot more than that in months to come. And we really would like to support the FCO being given funding to introduce a proper support system so that people know how to go through the system. If people are going to be able to secure their rights and not end up suddenly and overnight being illegal, as in a similar way to what we've heard earlier from the 3 million, then they're going to need help. They're going to need to know they've got to do it. That's the very first thing, how to reach people. They're going to understand what they've got to do, and they're going to have to be helped through the process of doing it, because we have our own vulnerable groups too. So I don't think that kind of thing can be left to voluntary groups such as ours. We simply don't have the resources, and it shouldn't be our job to do it.
Can I ask you, do you have any idea of the numbers of people who have actually applied already, and therefore how many?
Yes, I can give you some numbers. In 2015, before the referendum, the annual rate of applications within France for residents, bear in mind it's totally voluntary, 683 I think it was. Applications are currently running just over 13,000 a year. So you can see, since the referendum, an awful lot more people are applying. But We've had 2 years since the referendum, so let's say 26,000 people have applied or are in the process of applying. That leaves a huge majority who have not yet gone through the system. And our concern is not the people who are already in touch with groups like ours. They tend to be better informed. They tend to be the ones who make their contact. Our concern is with the people that we don't know. We don't know of them. They don't know of us. And it's very important that the British government puts some resources into reaching those people.
Can I ask you, is the impression amongst the community that once they've achieved the status, that will be sufficient for them post-Brexit as well? Will that status carry on unchanged, or will they be subject to some other system that might be introduced?
Well, that's the great unknown in all EU countries, is as to which registration system that country will adopt. Will it continue the current declaratory system, which, as Fiona said earlier, is working perfectly well, and it has a very well legally documented procedure in the Citizens Directive, which is very clear, and it provides the basis for each country to transpose into its own national legislation. And that is working well. Or will we be required in some or even all countries to have to register under a new constitutive system, which is allied to settled status? And that will work differently. That will be interpreted differently in each country. And that, again, that's the great unknown. And many of our vulnerable groups would perhaps struggle to legalise their residence under a constitutive system for many reasons, for many very good reasons.
Okay. Now, you had one final.
One very brief question. Thank you, Chairman. Michael Harris, you've raised the issue of potential disenfranchisement of British citizens living in European Union countries who may not have the right to vote in local elections, and that's obviously particularly strong in parts of Spain. To what extent have you discussed this with the group behind you representing the 3 million, Monsieur Hatton and Madame Donskoy? Have you had a liaison with them? Because it seems to me that 3 million in the UK have a useful role to play in communicating back, both to their member countries and to the EU, that this has to be a reciprocal issue. I would find it very hard to defend a reason why the several thousand European nationals living in my constituency can vote in local elections when none of the British citizens in Europe in the future could do so. So to what extent have you liaised with them to get them to make the point to the EU? Because this is something we have raised continually with them. David Davis has clarified that several times in meetings with us.
Okay.
First of all, we thank you for your question. We work hand in hand in advocacy with the 3 million, and we have done since last March and earlier. So, on the point of voting rights, first of all, I just want to correct a little bit